Good afternoon. I'm Stephen Harmon, and this is my presentation on international contracts for LSCM 4100 Global Supply Chain Management. In the executive summary, you can see that we're going to be talking about the international contracts. And basically, this presentation is going to cover the formation of contracts, implementation of risk reduction via CISG, understanding the role of ethical standards and how public perception can affect throughput, and let you know that businesses need to know how CISG is flexible and can assist. Uniformity of contracts is essential for success when connecting business internationally, of course. Another key aspect is going to be talking about how technology and software, as it goes along, how CISG has not just become rigid. It is flexible. This presentation also is going to cover dispute resolution through arbitration, as well as choice of law in contracts. Please take a minute and listen to this video on the international contract. It's a basic explanation.
The international contract is an agreement between two or more parties that come from different countries. That means that those countries may even have different legal systems, like common law and civil law. But at the same time, it's still international, an agreement between individuals of the same country, if it produces its effects on a foreign country. As a first step, the parties need to choose the law of the contract. Now, let's see how to create a proper international contract. The agreement must regulate all of the essential aspects of the contract in as much detail as possible. It should be sort of like a roadmap to be followed at every stage of execution of the contract. The text must be clear and the clauses must have a single meaning. These shouldn't be in contrast with each other, nor with the law applied. Otherwise, risks are annullability or nullity. Now, let's talk about the essential elements of the international contract. Formalities, languages, text as a roadmap, and the use of international contract models. The contract must be written when this form is required for the validity of the agreement. Remember, writing is always suggested. In fact, clearer you are, the less problems you got. The text can be written in one or more languages. To make things as easy as possible, the parties should select a reference text, for example, the one written in English. The qualities that the text must have are completeness and clearness. To achieve this purpose, the text must highlight premises and contract's objectives, a punctual terms glossary, parties and obligations, breach of contract responsibilities, remedies offered to the defaulting party. Now it's time for some useful advices. First of all, try to divide the text into many clauses. Then, if necessary, split the clauses into subclauses. Then, we need to identify carefully the parties' obligations, like transport, payment, time, and place. Remember to include a hardship clause in order to avoid an excessive burden on one of the parties. These models got standard clauses, but can also have several features depending on the particular case. The models can be made by private citizens or international organizations like the European Union or the Economic Commission for Europe.
All right. Okay, so when you're looking at the formation of contracts, U.S. businesses need to conform to the Uniform Commercial Code. Because of the international aspect in business, when doing international business, the businesses need to expect there's going to be some sort of conflict. There's going to be risks associated with international business. There's language barriers, cultural differences, economic differences, political differences. So it's important that businesses know the role that the Convention on Contracts for the International Sale of Goods, or CISG, plays, and how it has a harmonization of common law in that international realm. When businesses know and understand the differences between the UCC and CISG, the firms can navigate the contract formation more efficiently and establish contract performance standards that are agreed upon by all parties. Ethical standards. As everybody knows, businesses today they've become more conscious of their social and environmental impact just in everyday business. From forced child labor, sustainability issues, going green. These are just some of the issues that businesses are focusing on because their customers are speaking about what they want and their politics with their wallet, with their money. If this wasn't the case, it would be business as usual, from 10, 20 years ago. And because of this shift in more ethical and standards, businesses need to ensure that this specifically is put into the contracts because it could negatively affect them or it could negatively affect their partner that they're doing the forward business with. The CISG is flexible in its ability to adjust to emerging ethical standards issues. I mean, they've adjusted to what it is currently, and I'm sure they'll be able to adjust going forward. If there are ethical standards violations, CISG does allow for remedies to allow restitution. Uniformity of contracts. This is where, things need to be the same, even for both parties, not one-sided for an American company and lopsided for a Brazilian company or a Ugandan company. So it needs to be even and equitable for everybody involved. CISG interpretation is an important issue when it comes to this. Article 7, subsection 2 of CISG clarifies the interpretation because it is a precedent. And that precedent itself is basically that if there's no general applicable CISG principles, the interpretation reverts back to the national law. Software and technology regarding CISG. As we all know, technology, it's changing constantly. Technology has changed just immensely since the establishment of CISG in 1980. And like I said earlier, CISG is not so rigid that it can't adapt to technological changes. On the contrary, it does adapt. It's very flexible in its wording. It's kind of like a living, breathing document. Article 7 is applicable to software in particular because this article encompasses the understanding of goods. Article 35 deals with the conformity of products, and Article 38 stipulates buyers must examine goods within a set time frame. And Article 39 establishes the buyers must, within a reasonable time, address nonconformity issues with products with their partner. These are examples of how CISG is constantly evolving to whatever technology or software issues can arise in the future. Arbitration. This is something, if you're doing international business, even if domestic business, you're going to have issues with whoever you're doing business with at some point or another. And so arbitration is just one such way that companies can hash out their disputes. And arbitration is actually the preferred method of remediation because of its perceived fairness for all parties involved. The results of arbitration are considered legally binding for all parties, both parties. And the International Court of Arbitration, which is a part of the International Chamber of Commerce, is the leading global arbitral institution, and it handles most of disputes in international contracts anyway. An issue to note is that, like anything else legal, people can become biased, lawyers, the such, but it's important to note that arbitrators are held to a very high standard, and they are supposed to remain neutral in any and all cases so that everything is, the solution is more equitable for everybody involved. Choice of law. This is where it comes down to, like I said earlier, in making sure when you're drafting these contracts that businesses need to clearly state the choice of law when they're doing that. And they need to make sure that all that, it ties back into interpretation of laws. And it makes sense to include the Hague Principles in contracts because they tie into choice of law. And the Hague Principles deal with choosing the applicable laws, setting limitations on the applications of those laws, and allowing different laws to apply to various parts of the contract. You're picking and choosing what's going to work. And in conclusion, as you can see here, if businesses are to successfully navigate complexities around international business, they need to understand and apply the knowledge from a presentation like this, or do the research themselves. Associate themselves with partners in industry that are going to set them up for success if they're working with international contracts. It's also important to know the formation of contracts. It's the foundation that two parties, when they meet together, and it sets the course for their partnership. It's important that everything is laid out clearly, easily defined, and it's easy to understand terms. And by doing this, both parties are mitigating risk associated with international business ventures. Ethical standards, like I said earlier, are a very important aspect for businesses to consider when drafting contracts. The consumers today, they have access to information at their fingertips. I mean, they got a smartphone in their hand, they got a computer, a laptop. They can find out anything they want on what businesses are doing, what they aren't doing, and if they're holding up their end of the bargain ethically. So businesses need to strongly consider adding ethical standards into their contracts going forward. Businesses need to understand the importance of uniformity of contracts. Contracts that are uniform, they lead to a stronger, rock-solid relationship. Keeping things even for all sides, obviously it's beneficial, and it reduces the likelihood of contract disputes going forward. Like I said earlier, when it comes to the technology and software changes and CISG is 40 years old at this point. So it's important to remember that the articles built into the CISG, they account for changes and advancement in technology. They've accounted for all the technological changes and advancements since 1980, and they're going to do the same thing going forward. They're adaptive, flexible, and agile. If there is a conflict, businesses need to know that there are options. The most common approach, like I said, is arbitration, and businesses need to understand that the results of arbitration are considered legally binding for both parties. Lastly, businesses need to understand the choice of law and how that comes into play when they're working out their contracts with another international business. They need to go ahead and clearly define the choice of law, and the interpretation is less likely to be an issue. At this time, this concludes my presentation. If there's any questions or issues, please feel free to email me. Thank you.